Okay. Very good afternoon to all the participants present here. We warmly welcome you all to the webinar on the topic GST Appellate Tribunal. Now, before jumping into the content that we'll be discussing today, let's have a quick briefing about the firm HNA & Co LLP and our speakers for the day. HNA & Co LLP was established by Sir Madhukar and Hiragange in the year 1988 in Bangalore. As a firm, we have always focused in the practice in indirect taxation, which includes GST, customs, FTP, etc. Started with the head office in Bangalore, HNA is currently in 17 different cities all across India. Further, HNA & Co LLP firmly believes on knowledge sharing, and its partners have authored around 28 books in indirect taxation till date, which is published by leading publishing authorities. The partners are also actively engaged in teaching and writing articles in indirect taxations. Now, let's have a briefing about our speakers for the day. The first speaker for our day is CA Ravi Kumar Somani sir, who is a partner at HNA & Co LLP Pune branch. Ravi sir qualified as a chartered accountant in the year 2012 and is currently pursuing LLP. Ravi sir practices exclusively in the area of GST, customs, and foreign trade policies. He has performed indirect tax reviews across varied sectors and has guided clients on transactional structuring, workable business models, developing systems and processes for compliance under indirect taxes, which includes GST. He has given lectures at various professional forums on service tax and GST, written various analytical and issue-based articles on important matters concerning indirect taxes. Ravi sir has also authored multiple books and is a regular speaker at various forums like ICI, MCCIA, etc. Ravi sir currently heads the Pune branch of the firm. The next speaker for the session is C. Lakshman Kumar Kadali sir, who is a partner at HNA & Co LLP Hyderabad branch. Lakshman sir qualified as a chartered accountant in the year 2016 and is a partner at HNA & Co LLP, heading the legal division of the Hyderabad branch. He appears before various tax authorities, which include GSTAT, and is active contributor of case law updates and articles on various professional forums. His key area of specialization includes Indian GST litigations and pre-GST litigations, including customs and FTP. Lakshman sir is also involved in contributing seminars for various professional institutes, including ICI, and has contributed background research for books such as GST Judicial Precedents published by Taxpayers. He has authored a book, Practical Guide to Amnesty under GST. Next speaker for our session is Sriman Narayana sir, who is a partner designate at HNA & Co LLP Hyderabad branch. Sriman sir is a partner designate in GST litigation and practices at HNA & Co LLP Hyderabad branch. He specializes in handling end-to-end GST litigation matters, which includes drafting responses to show cause notices, filing and arguing appeals, and representing clients before adjudicating and appellate authorities. He has successfully represented clients in multiple complex litigation matters. In addition to the litigation practice, Sriman sir is an active speaker in training sessions conducted for GST authorities and regularly contributes to articles and judicial updates to multiple professional platforms. Sriman sir is currently pursuing LLB to further strengthen his legal expertise in the indirect taxation. Now, as we move ahead in today's session on GST Appellate Tribunal, we encourage each and every one of you to actively participate, reflect, and engage with practical insights that will be shared during the session. The Constitution of GST-AT marks a significant development in the GST regime, and understanding its framework powers is very crucial for every tax professional and businesses. With the rich experience and the practical exposure of our esteemed speakers, we are confident that this session will not only enhance your technical understanding, but also equip you with the actionable clarity for handling the appellate matters effectively. Now, without taking further time of you guys, I would like to hand this session over to Lakshman sir. Over to you, Lakshman sir.
Yeah. Chirayu, am I audible?
Yes, sir. Your voice is clear.
Okay, so before Lakshman begins the session, let me quickly just set the context. Firstly, welcome everyone for today's discussion on GST Appellate Tribunal. Just to give a context, we already did similar webinar about a couple of months back, which was more on the step-by-step understanding of the portal and also the key legal and technical issues in the entire GST Appellate Tribunal framework. So in today's discussion, we would not be going through step-by-step portal understanding per se, because that has already been covered. For those who are interested, the same is available, recording is available on our firm's YouTube channel. Maybe Chirayu, you can just share the link on the chat box here. So if anybody wants to listen to that at leisure.
Sure, sir.
Today's discussion would be more on the procedural aspects, and there were some follow-up issues relating to the portal which were pending at that time. And now that uh, we have actually filed as an office appeals for multiple clients of ours, so we also have more of actual filing experience to be sharing with all of you. So Lakshman would be, sharing the actual filing experience without going into step-by-step filing of the portal. And then we would have good discussion on critical issues in the procedural aspects. We will not be taking you through the procedures one by one. We will only look at discussing the critical issues or the common queries that we are getting from our clients. And then we will keep about 30 minutes in the end for Q&A. So if you guys have any questions, you can just put it in the chat box and we'll try to address all of your questions in the Q&A. We are trying to dedicate full 30 minutes for Q&A. So this is what is going to be the flow of our discussion. So I would now ask Lakshman to take up the issues in the portal that he has in his experience seen in last couple of months. Over to you, Lakshman.
Yes, sir. First of all, thank you, Chirayu, for introduction. So then, in last session, we have discussed step by step filing in the GSTAT portal. So now I'm going to give a quick recap of what are the different slabs in the GSTAT portal, different slides in which we need to give the information, and practically what are the issues we have faced during the filing and how to resolve it. So I'll quickly take you through those slides. Maybe I may take around 10 to 15 minutes. So after that, we can start this session on GSTAT procedure. Hello. Can someone confirm whether my screen is visible or not?
Yes, sir. Yes, sir. The screen is clear.
Okay, thank you. So first thing, this last time we have checked is the homepage of the GSTAT portal. So wherein we need to register ourselves as an authorized representative or a taxpayer or tax official or any other person. So taxpayers are required to register for filing an appeal in the GSTAT portal. Without this registration, we cannot file any appeal. So you need to register. And similarly, in case if any chartered accountant or advocate or CMA or CS want to attend before the tribunal as an authorized representative, they need to get themselves registered in this portal. So similarly, the tax officers, in case if they want to file an appeal against any taxpayer, they need to register in this portal. So these are the different categories in which we can register in this portal. So taxpayer registration, it is very simple. You have to give your GSTN number. Then all the details are getting auto-populated from GST portal. Only thing you just need to do is you need to enter OTP which you have received in your email ID, registered email ID, and your registered mobile number. Once it is done, you would be getting a user ID and password to the registered email ID. So after that, you can come back to this portal and you can log in and proceed to file the appeals. Coming to authorized representative, even this registration is simple. Only thing is you need to give your registration number, your name, and your details like address and email ID. So after this, you would be receiving a email with user ID and password to your registered email ID, whatever you are giving. So at time of registration, you need to upload your, if you are a chartered accountant, you need to upload your certificate of practice. If you are an advocate, you need to upload the certificate from the bar council. So these two documents you need to upload, and you are also required to upload the photo. So after that, you will be receiving user password, and you can come to this portal and check the appeals are filed, okay, with your name as an authorized representative. You cannot file any appeal from your portal. Voice clear or is it breaking? Can someone confirm?
Lakshman, it is slightly breaking.
Otherwise, I will do one thing, sir. I will just log out just
In the meantime, while Lakshman joins back, just to give everybody some insight, GST Appellate Tribunal now in various states, it has started. I'm sure many of you would be aware that 30th June is the last date of filing. Very recently, I was attending one GSTAT hearing at Principal Bench, Delhi. So where I came to know that even department is wondering why SSEs are not filing the appeals. And it seems that even at this point, the number of appeals filed are pretty less. And looks like most of the appeals people are going to file only in the month of June and maybe last 15 days. So that is one thing, maybe, we need not wait and start filing the appeals so that the chances of matter getting listed and coming for hearing can be much faster. Lakshman is back. Lakshman, you can just start the discussion again. Yes. Yeah.
yes. Sorry for interrupting. So, how is the here? Still, does my voice is clear, sir? No.
It is slightly breaking, maybe some issue with the internet. So in the meantime, just to give some update, the GSTAT benches in few places it has started functional. For example, there was one notification the Chennai bench is ready and functional. Principal bench, as usual, it is taking up anti-profiteering matters as of now. So that is there. But largely the hearings are still not in place, but the filing is happening. And although the filing process is a bit cumbersome, but still the matters are getting filed. As far as I would say the current status of this GST Appellate Tribunal filing is concerned. Just for my knowledge and understanding, maybe by a simple raise of hand, wanted to understand, like, any one of you have already filed the GSTAT appeal or have experienced the filing of GSTAT appeal? Maybe you can just raise your hands just to understand. So no hands raised, which means we are all waiting for others to file. I think maybe one another thing what I'm able to understand in the GSTAT is that nobody wants to go first. Everybody wants to first test the waters with someone else's appeals getting filed and try to gauge what kind of decisions that are going to come, how the benches are going to come out with decisions, and maybe then file the appeals. Lakshman?
Yes, sir. Sir, how is it now, sir? I changed the net.
Yeah, it is now proper. Yes, you can.
Okay. Sorry everyone for this inconvenience. Some glitch. We have discussed this taxpayers registration and at the same time authorized representative registration. So then we'll check the GSTAT portal. This is the thing, once you enter the GSTAT portal, so on left hand side you can see the appellant corner. So in the different subheadings are there like filing, upload additional documents and refiling. Again in filing, appeal filing and application filing. So in case if any taxpayer want to file an appeal, you should select the appeal filing option. So once the appeal filing option is selected, then you will be routed through the next tab. Next tab required to select whether you are having ARN or CRN or whether you are not having any ARN or CRN. What is this ARN? ARN is nothing but the application reference number of the first appeal. First appeal means you might have filed appeal to the first appellate authority, either joint commissioner or commissioner appeals. If you have filed that appeal online, you would have received this application reference number. So then you can see this ARN reference number, then you can proceed for filing the appeal. So once it is selected, all the details gets auto-populated GST portal. Like what is the appeal reference, what is the reference number of the APL 04, okay, what is the date of appellate authority order, and what is the adjudication authority order. All those details get auto-populated. So after this, you can, if ARN is not available, you can see there are two options. ARN is available. If you have filed your first appeal online, so then you will have this ARN. If you have filed your first appeal manually, then ARN is not available. So you need to follow this procedure. If ARN is not available, the details you have to enter it manually. So in this, one of the issue we faced initially, okay, when I explained in our previous session, so there is an issue with respect to this original adjudication order. At that time, we have to give 15 digits number. Then only the portal used to allow us. If you are giving less than 15 digits number, the portal used to restrict us from going forward. But now the issue is resolved. Now you can give the actual order reference number. Order reference number, and you can proceed to file the appeal. Now this issue was resolved by the tribunal. So then when to select ARN is available and ARN is not available. So last time I discussed this slide. So in which different criteria were given. If you see DRC 07 is uploaded online. First up also filed online. APL 04 is filed online. Then you select, okay, ARN is available and you can proceed to file an appeal. So then if you see DRC 07 is uploaded manually and first appeal also you have filed manually and APL 04 is also manual, but order is uploaded online. So in such scenario, you should select ARN is not available and you can proceed to file the appeal. So the detailed explanation, you can check it in our previous session. So the link was already shared by Chirayu. So then next, the other important slide is you need to select the jurisdiction, whether your case falls under state jurisdiction or with the principal bench. So here, in case if any of the issue relates to place of supply, then the jurisdiction falls with the principal bench. So you need to select this option as S. After that, you need to give brief of the grounds and brief of the issue. And you need to select the category of your case, whether it is input tax credit or classification of any goods.
Lakshman, your screen is frozen. Your screen is frozen. Maybe, yes, it is visible. Sure.
I hope my screen is not frozen.
Yes.
Fine, sir. To which slide, sir, should I go? From 14, sir?
Yes, 14.
Okay.
So here in first slide, we need to select this whether ARN is available or not available. So for this, different scenarios are there. So here I've given this just if the order is uploaded online, first appeal is filed online or not, appeal is filed online or not. So based on that, you need to select whether ARN is available or not available. So based on that, you can proceed to file the appeal. Okay, the detailed discussion you can check it in our previous video. Next, Sriman.
Yes.
So here as I explained, in case if any of the issue involved in the appeal pertains to place of supply, then the jurisdiction falls with the principal bench in Delhi. So you need to select that option. Does the appeal or application involve any issue over which only the principal bench has the jurisdiction? So here, if the issue involves place of supply, you need to select it as yes and proceed for filing the appeal. Next. So in this slide, you need to just give the brief of the grounds of appeal and issue under dispute. Here you need to give only the summary. You need not give a detailed grounds of appeal. Detailed grounds of appeal you can enclose at the end. You can give it as a document. Here you just need to give the essence of the issues involved and our grounds. In next page, you can select the category of the dispute. So your issue may relate to valuation issue, incorrect determination of time of supply, or issues relating to taxability, applicability of exemption notification. That specific category you need to select in this tab. So there are different categories which the government has given. From this, you need to select the specific category. So in case if it is relating to classification issue, then you need to give the specific details. If there are 3 products wherein the department is disputing the classification, for each HSN, you need to give the demand bifurcation. So you can go to next slide. Stream. Next. These are all the categories. So here, in case of misclassification, you need to give the demand amount HSN wise. So that before you start filing the appeal, you need to keep this ready, HSN wise bifurcation. So the next. So here you need to give respondent name. So respondent name is very important because there is one specific rule in GSTAT procedure rules which state that who can be the respondent. So the respondent is the jurisdictional commissioner. It's not your appellate authority. If you see, you are filing an appeal to appellate tribunal against the order of the first appellate authority. So please don't select first appellate authority as the respondent. He is not the respondent. So your jurisdictional commissioner is the respondent when you are filing appeal to the GST tribunal. So this you need to keep it in mind while filing. Otherwise, you may receive a deficiency memo. So in many a times the DR, the department representative, will dispute this aspect during the course of hearing. So then what happens is, if you want to change this respondent details, you again need to file an application, miscellaneous application for change in the cost title. So then it will again take some more time. So it is better to fill it properly at the time of filing itself. Next. So then authorized representative. So here the taxpayer, when he is filing an appeal, he need to select who is the authorized representative. As I mentioned, if any chartered accountant wants to act as an authorized representative, so you need to register. Only when you register, the taxpayer would be getting your name here. He can search your name and he can add you as a representative. Next. So next, demand details. If year and age available, all these details are getting auto-populated from GST portal. Otherwise, you need to fill it manually. So after this, you need to make the pre-deposit payment. So this pre-deposit payment, you need to pay it in GST portal only. So otherwise, you need to execute through DRC 03. So after pre-deposit payment, the next step is relating to appeal filing fee. Next slide stream. So here appeal filing fee. So this is different from pre-deposit. Pre-deposit is different and appeal filing fee is different. Appeal filing fee, it depends on the disputed amount. For each 1 lakh, they have prescribed 1,000 rupees. So based on the disputed amount, you need to determine the appeal filing fee. So the maximum amount is 25,000. So 25,000, you need to make the payment. It will route you to internet banking or credit card or debit card, or you can also pay it through UPI, or you can pay it through Bharat Post offline utility as well. So after this payment, you can proceed to upload the document. Next section. So this tab, add document tab. So here you need to add each and every document. So there is document type. When you are uploading, you need to select the document type like APL 04, order in appeal, order in original, show cause notice, any other annexes. In that sequence, you need to upload all the documents and you can proceed to file the appeal. So few printing instructions which you need to take care while uploading these documents is all documents should be on A4 size papers. and the taxpayer has to sign on each and every page at the bottom of all the pages, and you need to affix your round seal. And order in appeal must be self-attested. So these conditions are there while uploading the portal. And once you file an appeal, then you will get this provisional acknowledgement, Part A, APL 02. Once it is received, all your documents will go to the concerned registry, and the registry will verify. And in case if they found any defects, they issue a deficiency memo. Next slide, Sriman. So here, if you see in one of our case, we have filed this appeal. In e-file cases, it is showing as 1. That means we have filed one appeal and there is a defect. So then next slide. So in case if you go to e-file cases, then you will find this defect. This is the defect issued by the registry. You can view the defect sheet and you can view the details and you can understand what is the defect issued by the registry. Next slide. So this is a defect issue. In this case, they have asked us to upload the show cause notice copy. So while filing the appeal, so it seems we have missed the uploading the show cause notice. So they have issued a deficiency memo asking us to upload the show cause notice. Like that, in case if you miss any documents, okay, they are issuing a deficiency memo. In one of the case, they have issued this deficiency memo for clarity on the pre-deposit payment. Because in our case, we have made the payment through DRC03. So the registry did not understood how we have made the pre-deposit payment. Though we have clearly mentioned in the covering letter, okay, but they have issued a deficiency memo. Then we have refiled the appeal by giving the clarification. Next. So here, left-hand side, you can see if you want to do upload any additional documents or refiling option is available. If you receive deficiency memo, you need to either upload the additional document or refile the appeal along with all the documents. Next. So this is the uploaded document list. Once you file the appeal, we have the access for the documents uploaded in the GST portal, GSTAT portal. So you can download all the documents whenever you require. Next. So that's all. These are the different issues at the time of filing what we have faced. So there may be many other issues which other tax professions are facing. So we need to see, and the registry is also very proactive in clarifying our doubts. Whenever we have a doubt, when we approach the registry, they are clarifying. Like one of the documents which we need to upload is affidavit. Okay, that is a mandatory document to be uploaded. So we have some confusion what documents, what affidavit we need to upload. But when we approach the registry, they have clarified that it is APL 05 form which we need to upload as an affidavit. So like that, wherever registry is open, you can consult the registry and get the clarification from the registry. So this is all about this GSTAT portal related issues. Now we can take up the GSTAT procedure rules.
Yes, sir. I'll start. Good afternoon, everyone. As discussed, if you want detailed discussion on the GSTAT portal issues, you can always find our can always go to our YouTube channel where we had uploaded a video. I think Chiravi has also pinned, Rohit has pinned the YouTube video where you can see the discussion, what we had discussed in the last session, which had happened in the February 2026. Now we'll be discussing GST procedural issues in the question and answer format. I will be moderating and asking the questions to Ravi sir and Lakshman sir. They'll be answering the how to deal with these practical issues, and they'll be answering your questions as well. If you have any questions, you please post in the chat box. So in the last half an hour, I'll take up the questions and I'll ask Lakshman sir and Ravi sir will give you the answers. So I request even during the session, if you have any questions, you please post it in the chat box. In the last half an hour, it is dedicated to the further Q&A. Sir, one of the main thing when you go to the GSTAT portal is that they have given for the authorized representative also the option to get registered on the portal. So we all know authorized representative plays a crucial role in the GSTAT proceedings since he is the person who is representing the client taxpayer before the authorities. So can you tell us who all the persons can be act as authorized representatives before the GSTAT tribunal, sir?
Yes. So, firstly, I think there are a lot of questions that have come in the chat box. So, we would take up all these questions in the end. We are just keeping note of all these questions, and it will be taken in the end. Just, as an assurance to the people who have posted the question. Shriman, with respect to authorized representative, it can, the law says that it can be a relative of the taxable person, a regular employee. If someone is an employee of a company, that person can be the authorized representative. A chartered accountant doing practice, an advocate, a past GST officer, class B GST officer who's been a class B for at least 2 years, and also a GST practitioner also can be an authorized representative. In fact, cost and management accountants and company secretaries practicing can also be authorized representatives. So these are the people who can represent the client, taxpayers for their matters in a GST Appellate Tribunal. Only thing is GST tax practitioner thing, I'm not sure whether they are nowadays conducting exams or not. I have not heard much about it. But yes, that is also a category which is there.
Okay, sir. Sir, as you mentioned, there is chartered accountants who are in the practice. We also have the concept of part-time certificate of practice. So the chartered accountants who have taken the part-time certificate of practice, are they also eligible to appear before GSTAT, sir, as authorized representatives?
Yeah, in ICI, there is this concept of part-time COP.
Yes.
In my opinion, part-time COP people are not allowed to do attest function. However, I don't see any restriction on appearing before any appellate authorities. So at the most, the restriction on attest function or the signing or certification function, not for appearance. So in my opinion, appearance should be possible.
Okay, sir. Now let's about other lawyers, sir. We'll speak about the lawyers. We also have this concept. Once we pass the CA exams, we should register our name in the members, and we should take this certificate of practice. And for the lawyers as well, they have this. Once they complete their LLB, they should register as they should write these bar council exams, and they should register in the bar. So, is there any restrictions for the lawyers that who are the people who are registered in the bar? Those are the eligible to appear before the GSTAT or authorized representatives?
Yeah. So see, there's a fundamental difference between lawyer and advocate. We need to understand that. Someone who has cleared the law degree or LLB exam is a lawyer, but advocate is the one who is registered in the bar council. Correct?
Okay. Yes.
So
Yes. Sir.
the law provides advocate, not lawyer. So one has to be registered in the bar council to be eligible for appearance before the tribunals, GST tribunals.
Okay. Thank you, sir. Next question is for Lakshman, sir. Sir, am I audible?
Yes.
For this, Sriman, one point I wanted to highlight here.
Yes.
Actually, there is one issue in respect of this group companies. Sometimes what happens now, let us say I am a group having multiple companies, and but there is a single tax team, let us say. So now the law says that it's only an employee who can do. But let's say I am an employee in ABC Limited, but in a group there are PQR, XYZ, and multiple companies. Then whether this person can appear because they have a group level taxation team for all the companies. So there I am able to see a practical difficulty or practical challenge because law says regular employees. Now either way, that person either has to take multiple employments, as an appointment, because joint employment is not barred under Indian laws. So the person might have to take multiple employments in all these group companies as an appointment letter and everything, so that he's an employee, but although he's taking salary from one company and continue to appear. Or the person might have to register as a GST tax practitioner. There is one funny interpretation. There is a term called relative. Relative also can be go for the hearing. Now, the question that comes is relative. Should I link the term relative with the related person, which is there in section 15? Because section 15 related person covers all those group companies, common director, common shareholding, all those things. Personally, I feel it is a bit of a stretched interpretation. That's not the intention, because a relative more is like an individual sort of thing.
Yes, sir.
And section 15 related person is more in that context. But I'm just telling you that is one thing maybe someone can explore. But again, this is something that can be looked at. So, but this is one of the challenge in case of group companies for authorized representative.
Okay, okay, sir. Lakshman sir, as you explained in the portal, when a taxpayer files an appeal, he has to provide the details of authorized representatives.
Yes.
Right. As we all know, there is reasonable period of time between the date we file appeal and with the date we get the hearing. What if in this period, during that period, the authorized representative changes? What should the taxpayer do?
Yes. So in case if any taxpayer appoints one consultant initially, and if they want to change it, okay, after filing the appeal, so the one thing they need to do is, so they need to take an NOC from the previous consultant, and this was specifically mentioned in Rule 73 of GSTAT procedure rules. Okay, they need to take an NOC. So after that, they can appoint a new consultant. So that is the procedure they need to follow. In case if the previous consultant is not giving the NOC, then they need to file an application before the tribunal for changing the authorized representative, and a copy of that application should be served to the previous consultant. So after that, the matter would get listed before the tribunal. The tribunal will consider the application and they may allow the change in the authorized representative. So now this is critical actually. So if there is a change in consultant, the rule has specifically asked us to get an NOC. If you see the previous rules, previous GSTAT procedure rules, this kind of document is not mandated. So there is no requirement. So once you file in wakalat, okay, with a new, if you have given wakalat to the new authorized representative, then he can file the same with the tribunal and he can proceed to argue the matter. But as a good practice, the courts have been and tribunals have been consistently asking for the no objection certificate. This is not mandatory under pre-GST regime, but it is as a good practice that tribunals are following it. And there are a few High Court and Supreme Court decisions also supporting this, okay, taking an NOC from the previous consultant as a good practice. Okay, but under GST, they're bit, they have mandated this filing of NOC from the previous consultant.
Okay, sir. So in addition to that, can authorized representatives can sub-authorize other professionals, sir? Or for that matter, can he sub-authorize their own qualified staff?
Yes, Sriman. So one thing you need to check is while taking the authorization from the taxpayer, okay, are you taking authorization to subdelegate or not? That is one of the important aspects. In case if you are taking powers from the taxpayer to sub-authorize any other person, then you can do it. But in principle, there is one legal marking which says that the delegate cannot further delegate. Okay, so but you should have express right in the wakalatnama or authorization stating that you can further subdelegate it to a different person and to your own employees. So while taking the authorization, you need to specifically take that power, and you should also mention the names of the person whom you can authorize in your own office. So based on that, they can subdelegate. But only problem which we may face is for all the chartered accountants, only a person who is holding COP can appear before the tribunal. So that we need to ensure for all our employees who are going to appear before the tribunal, we may have to ensure that we should have either part-time COP or full-time COP.
Okay, thank you, sir. Sir, whenever we discuss about the GST tribunal before the clients, the taxpayers, the main important question they'll ask is that how much time will it take to get the hearing from the tribunal? Like if we file today, we all say them today, we all communicate them that this is the due date. Before 30 June 2026, we should file the appeal before the tribunal. And the next question is when we'll get the hearing. So generally, how much time will it take, sir, to get the hearing from the tribunal?
So that is a very impractical Sriman to say. So because it depends on different factors. But now if you see GST tribunal, it was constituted after almost 8 years. Okay.
Yes, sir.
At the time of constituting the GSTAT, the president has mentioned that there are around 4 lakh appeals, 4 lakh order appeals filed by first appellate authorities. In case if 4 lakh appeals are being filed by taxpayers now, you can see how much time it will take. It will take a minimum of 3 to 5 years to clear the baggage on the first day. Okay, you leave about the appeals which are filed after 30th June. In case if those 4 lakh appeals are filed by 30th June, then it will take 3 to 5 years for disposing of those cases. In pre-GST regime in GSTAT, at least in Hyderabad, the tribunal is taking up the appeals filed in 2013 and 14. Now we are in 2026. Now the tribunal is taking up 13 and 14 matters. So you can understand it will take a lot of time. But if you want your case to be disposed of early, the main thing which you need to do is you have to file your appeal early, because the cases will get listed in a sequence. So if you file first, your case will come up for hearing first. So you please try to file the appeals as soon as possible so that you can dispose of your cases at the earliest.
Okay, sir.
This
Sir,
can
there
be
is a
mainly for refund matters, Sriman. If someone
Okay.
has a refund matter and a matter not involving too much of interpretation, more of reconciliation matter, it's recommended to file early. There can be an advantage in the hearings coming a bit faster.
Okay, sir. So next
And the
question to
other thing
Ravi.
is, that big demands are also seen. Wherever the taxpayer has paid pre-deposit, huge pre-deposits are lying with the department. Okay, for these reconciliation issues. In those cases also, they need to file it early and get it disposed and get the refunds. That also we need to take care.
So Ravi sir, in those cases where the taxpayer has paid huge amount of pre-deposit, if we go through this GSTAT provisions, applicable rules and all, there are two terms, sir: urgent application and early application. So what is the main differentiation between these, sir? Urgent application and early application.
Okay, so in the listing of cases, there is this concept of urgent hearing.
Yes, sir.
So let us say
Early.
there is a recovery which is there, or there is an attachment of bank account attachment is there, or on account of any other reason, we see that the business is going to get impacted. In those extreme cases, the taxpayer can go for urgent hearing application, in which case the matter will be taken on urgent basis. In fact, it says that if you can get the matter listed on the next following day, provided you move the urgent hearing application before 12 noon of the day. They may also take up in some cases between 12 p.m. to 3 p.m. and the matter can come in the immediate next day. But in my opinion, urgent hearing has to be like, really very urgent, because otherwise, you are going to see, one may say that, for me, my case is the most urgent. That is for you, but not for the, the bench. So my only worry is that many people are going to file these urgent applications and most of them would be rejected. Only those extreme ones would be taken up because it's immediate next day the bench is ready to take up. So for most of the ones who want their matter to be listed faster, they should not go for the urgent hearing plea. Rather, they should look at early hearing application. So early hearing is something, my case is there. I don't want my case to be like an example, what Lakshman told, 2013 to be coming in 2026. I would want it to be disposed of in next 6 months to 1 year or so. I can write a early hearing application, which is not urgent hearing, it's an early hearing. So that's a more appropriate application rather than urgent hearing application. That's a distinction between these two, Sriman.
Okay, sir. Thank you for providing the clear.
Yes, sir. Sir, one thing relating to this urgent listing, sir. So this may come in a scenario where the department is initiating that recovery. Okay, so if you see the application is pending before the appeal is pending before the GSTAT. We have filed it online, but they have not given the final appeal number, sir. Because the appeal will be considered as filed only when you get the final appeal number. Okay, in between they might have issued the deficiency memo and it is pending before the tribunal. Okay, for verification. Meanwhile, in case if the department initiates in a recovery provision, so we can request the bench to take up this defect memo and clear the defects and give a appeal number so that we can submit it to the department for removing the attachment. So that may be one scenario which we can do.
Correct.
Okay, sir. Lakshman sir, when it comes to hearing before the GST tribunal or in the matter for the GSTAT as well, we'll always listen this term called cause list.
Yes.
We don't hear it in adjudication proceedings or applied proceedings, but only when it comes to tribunal, we hear this term of cause list. Can you explain what is the cause list and what cause list contains and all?
Yes, Riman. So if you see cause list contains cause list as per GSTAT procedure rules, they give cause list every day for the hearing they are going to take up on next day. So that cause list contains your appeal number, the name of the appellant, and the who is the authorized representative, and what are the cases which the bench is going to hear on the next day. So it contains all the details. So if you want to check whether your case is listed for hearing or not, every day you need to check the cause list. So that is one of the means through which the tribunal is communicating that your case is going to hear on a subsequent day. Okay, and at the same time, okay, there are different mechanisms in which the tribunal is going to communicate to the taxpayer and the authorized representative. Okay, there is one specific rule which says that the communication. Okay, if you see even even a regular GST authorities also, the communication mechanism is the GST portal, or they may send it through email, or they may send it through post. So the same provision they have referred in GSTAT procedure rules also. GSTAT is also going to send, okay, going to upload the hearing intimations in the GSTAT portal, or they may send it to the email. Okay, so you need to check your email ID, whatever you have given at the time of registration, or you need to check your GSTAT portal frequently to come to know whether your case is listed for hearing or not. So this is the communication mode which the GSTAT is adopting.
How frequently they'll upload this cause list, sir? Is it weekly or daily or monthly?
Yes, so as per procedure rules, Sriman, so they told they are going to upload it daily. So daily it would be very difficult, because in case if we come to know about our hearing tomorrow, it would be very difficult to prepare and present the case. Okay, generally in pre-GST regime in GSTAT, okay, they upload this cause list weekly, on a weekly basis. Every Friday they upload the cause list for the next week, so that everyone will have sufficient time for preparation. So in these cases, what we can request the concerned GST benches is, we can request the registry to upload this cause list on a weekly basis instead of daily basis. So mostly they will agree, because they also know that it is very difficult to prepare within that short span. So generally the tribunals agree for this. So that we need to do proper representation to the concerned benches.
Okay, sir. Sir, one thing, when the taxpayer receives the personal hearing intimation from the adjudicating authority or appellate authority, they will mention the specific time, sir. That's like on particular day, 2 o'clock or 2 o'clock, 3 o'clock, 3 p.m. at the afternoon, and this and that. But when it comes to GSTAT, they'll upload the cause list. They'll put your in the serial number, serial wise, they'll mention the taxpayer's name and the respondent's name, and they'll mention the time is 10:30 to 5.
Yes.
So how to, based on your practical experience, how to determine at what time you should go to GSTAT so that you will able to efficiently use your time, sir, to get the hearing?
Yes, so tribunal, Sriman, we need to go there. Do not give specific time slot, as you mentioned. They simply mention 10:30.
Yes,
Okay, we need to reach the tribunal by 10:30, and we need to wait for our case. Okay, because each case, assume the tribunal has listed 20 cases on a particular day. Your case may be listed at serial number 15. Okay, don't think that serial number 15 will come after 2 hours or 3 hours. Okay, and go by 12 o'clock or 1 o'clock. But by the time the court may get closed also. Because what happens is, okay, first 14 cases, they may take an adjournment and they may not argue the case. So the first case would be yours to argue. So we have to be in the tribunal by 10:30 so that we can appear and argue our case. Sometimes your case may not reach. In case of the first case itself takes 2 or 3 hours, because all these issues which are going to tribunal may involve complex reconciliation matters and complex interpretation matters, which usually takes time. And at the same time, GSTAT is constituted recently and the judges are also appointed recently, and they should have that relevant experience. And while giving any decision, they will be very careful in the initial stages. At least maybe first 6 months or 1 year, the disposal rate will be bit less because they need to do a lot of research in the back end while giving any decision. So it will take, okay, sometimes it may take 1 hour for one case, 2 hours or 3 hours. And that may not happen on one day also. They may postpone to a different day. So all these contingencies are there, but you need to be in tribunal by 10:30 a.m.
Sir, let's suppose my serial number is 25 on that
Yes.
day, based on the cause list, and my case do not reach on that day.
Yes.
How do they note down in the records that whether they note down is one hearing has happened, or how do they record?
No, they do not consider it as a hearing because we did not got any opportunity to argue. So they simply mention that it was adjourned in due course, as the matter is not reached. Okay, it will not be considered as a specific hearing.
Okay, sir. Sir, as you mentioned adjourn, is there any restriction on number of adjournments that the taxpayer can take?
Yes, Sriman. The law provides that you can take a maximum of 3 adjournments, and the bench can grant only 3 adjournments. That is for each party. That means taxpayer can take 3 adjournments, and at the same time, DR also can take 3 adjournments. Okay, that is the maximum number of adjournments. But if you are having any sufficient cause, sufficient reason for taking another adjournment, you need to explain it to the court. The court may consider, and in case if the court feels that the reason is valid, they may give more adjournments than 3. That is practically happening in GSTAT, and we hope the same thing continues in GSTAT also.
Okay, sir. Ravi sir, so what are the consequences that the taxpayer will face if he doesn't appear before the GSTAT on the scheduled date?
Okay. So one is, let us say if the taxpayer is knowing that he would not be able to appear on a particular case, then he need to seek adjournment for the particular, matter. And the rule says that the adjournment must be actually sought by physically being before the bench. And accordingly, the bench would adjourn the hearing to any other date.
Okay.
Question may come as to the matter of the fact is I'm not able to appear for the hearing. And where is the question of me going and saying I will not appear or I need adjournment? So this is something a practical thing. But what I have seen largely is that if we send an email to the registry or make a written letter to the registry, they would, consider it and discuss with the bench and give the adjournment to the matter. So that is something we have seen practically, happening. In fact, in one of my GST Appellate Tribunal principal bench matter, we did the same thing because it was in Delhi, and it was duly adjourned basis the letter and the email that was sent to the registry. Having said that, it's very important that if someone is appearing, they do appear, because if the appellant doesn't appear, then the bench, and if the adjournment is not sought, then the bench may actually pass the order on merits. And if the order is passed on merits, then nothing can be done. I mean, that is done. Then the only thing is you go to High Court. But there are most likely chances that the bench would not pass the order on merits. They would rather dismiss the matter on account of default in appearance. In case the bench dismisses the matter on account of default of appearance, then the authorized person has to again appear before the bench, explain the reasons why he or she couldn't appear in the earlier this thing. The bench is satisfied, they would restore the appeal which was earlier dismissed. Correct? So this is very important, that what Lakshman mentioned, right? 1031 has to be in the GST Appellate Tribunal. GST Appellate Tribunal is not a part-time profession. It is not like something I would do as a passion. This certainly passion is required, but this is a very serious profession because it involves huge stakes. Very important is, if I am a respondent, then, and if I don't appear, then tribunal can actually pass the ex parte order. This is very, very important, especially in cases where department is filing an appeal and taxpayer is a respondent. Then your appearance become all the more critical, because in those cases, the highly likely chances are that the matter would be ex parte order would be passed. So these are the consequences of adjournment. So far as the bench is concerned, they can take adjournment anytime. There is no issue for them.
Okay, sir. Is there any mechanism available, sir, for a taxpayer to take hearing virtual?
Yes. So hearing, first preference is always physical, and virtual hearing also can be taken. It says by way of permission of the president. But in my opinion, again, this letter business should work even in this case, provided we inform them in advance that we will be appearing online. I'm sure registry would take care of all the online links, and they would share all the details. In fact, in GSTAT also that is happening, and quite effectively the online hearings are happening in GSTAT as well. So GSTAT is more moving towards absolute electronic way of doing. So in my opinion, electronic would be easily accepted.
Lakshman sir, based on your experience, what do you suggest to taxpayers, whether to go for physical hearing or to go for virtual hearing?
So wherever it is possible, Sriman, so it is always preferable to go physically only. The tribunal allows. Physically is a better thing, so that we'll communicate effectively and the other party also can listen effectively and take a call. And at the same time, in case if you want to refer to a lot of documents, lot of evidences, if you wish to show it to the tribunal, okay, for taking a decision, so it is always preferable to go physically, and it will be convenient to both the people, both to the bench, DR, and the appellant as well. Okay, so it also requires, because if you see the case laws, whatever you submit, okay, that you can read it out, you can go to the respective page number. So all those things, it will be convenient for them. So otherwise, even virtually also it is fine. In many high courts and tribunal also it is happening. It is going fine. Okay, but preferably in case if it is possible, it is you prefer to go physical.
Okay, sir. Sir, my question is to Lakshman sir. Sir, in complex situations, we observe, sir, the adjudicating authority has issued the show cause notice for multiple periods. And now the appellate authority, when he is passing the orders, he will pass the order for each financial year, he will pass the one order. So in that cases, when one show cause notice is there in the case and multiple orders are involved, whether the taxpayer is required to file one appeal or different appeals for the different orders.
Yes, Sriman. So there is a specific rule in GSTAT procedure rule, which says that you have to file appeal against the order in appeal. So as many order in appeals are there. Okay, so in your case, though show cause notice is one, but the order in appeal is there are 4 order in appeals. You need to file 4 different appeals to the GST tribunal. And the GST procedure rules has also explained about a different scenario, wherein there are multiple show cause notices and multiple order in originals are also there, but there is only a single appellate order. For multiple financial years, appellate authority has passed only single appellate authority order. So in that case, do we have to file only one appeal? No. The GSTAT procedure rule says that you need to file as many appeals of as many order in originals involved in the case. In this case, in my example, there are 4 order in originals, 4 adjudication orders passed by the adjudicating authority. So you need to file 4 different appeals to the GST tribunal, though appellate authority has passed a single order. So this we need to be careful, Sriman. So when we are filing appeal, we need to check how many originals are there. Otherwise, what happens? You might have filed only one appeal to the GST tribunal, but you are required to file 4 different appeals. So this issue may come up after certain period, maybe after 3 months or 6 months, when the matter is listed before the tribunal for final hearing. Then DR may object this. Then DR may say that instead of filing 4 appeals, they have filed only 1 appeal. So then it is not possible for us to file appeal at that point of time, because by the time limit of 3 months and additional 3 months of condonation period might got expired. So that becomes very difficult. So we have to be very careful at the time of filing appeal. Okay, this is one of the important aspect which you need to take care.
So to summarize it, the taxpayer has to determine based on order in originals.
Yes,
How
exactly.
many order in originals, we have to file that number of appeals.
Yes.
Sir, my other question is the GST contains the provisions related to e-way bills and investigations. And
Yes.
there are high possibility for the taxpayers that they may face these issues in other states in which they are not registered.
Yes.
Right. Let's suppose a supplier from Telangana supplying goods to Maharashtra. He may not register in Maharashtra, but while he generates the e-way bill, his goods may be confiscated in the Maharashtra. Now,
Yes.
since he is not registered in Maharashtra, is there any mechanism available for him to file an otherwise in which jurisdiction, which GSTAT he has to file an appeal, sir, before the GSTAT?
Yes. So it depends on the jurisdiction of the officer who has passed the order, Sriman. So in your
Okay,
case,
sir.
the detention order might have been passed in Maharashtra. Against that, you might have filed an appeal to the jurisdictional appellate authority in Maharashtra. So now the appellate authority, against that appellate authority order, you need to file an appeal to the tribunal. So that is, you need to file the appeal to the jurisdictional tribunal. So in Maharashtra, jurisdictional tribunal, you need to file the appeal. So that is the mechanism. And coming to practically filing this appeal, so as of now, we are facing difficulties because we have few cases and we are trying to file appeal to the tribunal, but there is no option to file an appeal to the tribunal. So tribunal appeal, we need to file it online. It is completely online. So if you see, when I'm explaining that registration, there are four categories. One is taxpayer, authorized representative, and the tax official, and any other category. That any other category, we tried it. Okay, because we do not have any registration in Maharashtra. We tried to register under any other category, but it is not allowing. It is stating that it is only applicable for the tax officers who are not having the login. Okay, so it is very difficult and we are not able to file appeal in the GSTAT portal in those e-way bill cases in a different state. So this, we are contacting the registry and we are trying to get a clarification. So otherwise, we need to file the appeal before 30th June. So it becomes very difficult. So we need to act fast. Wherever there is a difficulty, you should approach your respective registries, jurisdictional registries, or you can raise a grievance in the GSTAT portal, so that they resolve it faster.
Okay,
and this scenario is equally applicable for the DGGI cases where the CBSI has appointed common adjudicating authorities in a different state. So in those cases also, you need to file appeal in that respective state. If you do not have registration, it becomes a problem. So we have to be careful.
Okay, sir. Sir, my next question is to Ravi, sir. Sir, now we are facing a problem that we have multiple cases, but if we go into the cases order in appeals, they have all the similar issues. Like if I take my whatever the order in appeals in my hand, there let's say there are 10 order in appeals. In 8 order in appeals, they have similar issues such as 2A versus 3B. Supply registration has been cancelled retrospectively. So in that case, when I file an appeal before the GSTAT, can I request to the members? Can I make a request to the members to tag them and to listen it one go?
Yes. So see, currently also in CSTAT, it is accepted wherein let us say if a matter is a covered matter. I mean,
Okay.
I'm thinking general situation or general scenarios. One is a covered matter. Let us say there is already a set precedent of the same bench, or the High Court of the same jurisdiction. So those cases generally bench takes up, we can say, to tag it with this matter and is taken. And also another situation could be, let us say currently we are appearing for 17-18 matter, but for the same issue 18, 19, 19, 20 and 21 notices and orders have come. We can request the bench to tag all of them together. So long as the facts are same, the bench would ask to tag all the matters, and then another date would be given where all the matters together would be taken up for hearing. In fact, that's an effective strategy one must apply.
Okay, sir. Sir, my other question is, other problem which being faced by taxpayers is, particularly who are registered in North India, sir. They are receiving the notices and orders in the Hindi language. And to some of the taxpayers who are registered in this southern India, they are receiving this notices and all correspondence from the department in the local language. In that case, is there any requirement for the taxpayer to translate those documents and to file before the GST tribunal, sir?
Yes, yes. So all the documents, appeals and everything have to be translated in English.
Okay, sir.
Duly certified translated copy has to be submitted in English. It is very, very important. Not just the order or the notice. You gave an example of order or the notice. Let us say you are doing appeal for a joint development agreement, and all your agreements and everything is in Marathi or Telugu. Correct. So all these documents should also get converted into translated into English, duly certified. Now I'll tell you the critical part. The critical part is that practically what we are seeing is that translators are taking their own sweet time. At times, even 15 days they need for translation. Now, let us say if my appeal filing due date is near and translator is going to take 15 days, then that is a problem I am landed myself in. Next thing is that the cost of translation also we are seeing is quite, hefty to an extent like 1,500 to 2,000 rupees per page. So I don't know whether I should ask client my fees or translator's fees as a part of this GST tribunal, this thing. But this is, I would say, see, these are the small things when we talk, but in reality and practical terms, these actually become the big, animal that come out of nowhere in the, appeals. So this translation thing is very critical. And just to put one more point, connected point, which is, very cumbersome thing is these signatures. Each and every document, each and every page, they want the signatures, including the, additional documents. So how this signature thing is going to work out is very difficult, because I don't know. I am actually thinking in my office I should put one stamp of my signature and keep it, and one clerk should be there only, stamping my signature, because it's not possible for me to sign. Of course, digital signature can also be done, but it takes time for each page, to be digitally signing. So these are practical difficulties. I'm sure some easing or clarification should come. See, the critical part is in GSTAT, the earlier central excise, they used to say you pass the order and the basic documents you upload and you file the appeal, and within 30 days you give all the rest of the documents, supportings. It was allowed, but here they say everything should be given as a part of the first submission itself, including your relied upon documents. That is something that makes the whole process quite cumbersome. And while they have mentioned that, initially we will be sort of, easy, but what we are
Yes,
seeing
sir.
is ground level, they are not accepting. A lot of deficiencies and discrepancies are coming at the ground level. So these are some pointers.
Sir, what if, as you said, that every document needs to be submitted at the time of filing an appeal before the GST tribunal? What if the taxpayer discovers or authorized representative discovers that there is additional information which is required to be submitted to strengthen the case? Is there any possibility or mechanism available for the taxpayer, sir, to submit additional information?
Good question. So see, additional evidence, additional information, so far as it doesn't change the course of the case, or you're not totally bringing into something totally new factual stuff, it's not a problem. But if it is totally changing the course of the case, then I don't think that would be acceptable generally. Having said that, any additional evidence as a general principle would not be allowed at the tribunal level. Reason being, while tribunal is also a fact-finding authority, but it is expected that at the assessment, scrutiny, audit level, all the major fact-finding and evidences gathering is completed. One has to really establish before the tribunal the fact that the evidence was given but was not accepted at that time. The assessee was, actually there was some circumstances wherein he was not allowed to give the additional evidence, or he has given, but something like that. A principle of natural justice or opportunity not being given has to be established for the tribunal to take up the additional evidence. Very importantly, if tribunal because tribunal has got lot of powers in accepting. Tribunal say it's my court and I will accept. But even if tribunal accept, let us say, certainly tribunal would have to give time, opportunity to the DR, the departmental representative, to go through the additional evidence, the witness or whatever, examine the documents, and then come back, and they may also file then their rebuttal to the additional evidences that we have given. So certainly additional evidence is there, and that is where we say that, while tribunal is important, but a lot of work, groundwork is actually needed at the assessment audit level. If the case is not done properly there, tribunal, we cannot tweak into the facts too much.
Okay, sir. Lakshman sir, as we all know, limitation plays a crucial role in GST litigation because they have given strict timelines to when to file an appeal and all. As we all know, the appeal before the tribunal should be filed within 3 months from the date of communication of order. So how it should be calculated, sir, the 3 months? Is this months or number of days in the month, or how it? Can you explain the mechanism how to calculate this period, sir?
Yes. It should be months even, because 112 says that 3 months from the date of communication. Okay,
Yes, sir.
within 3 months, okay, you need to calculate. And at the same time, Rule 3 of GSTAT procedure rules states that the first date of receipt should be excluded for calculation of 3 months. So assume you have received some order on 24th, today, 24th April 2026. So first day you need to exclude. From tomorrow you need to calculate the 3 months. Okay, so the last date is getting expired on 24th May, June and July. 24th July 2026 is a due date. That is one thing. So the other thing is, what happens in case if your due date, the 24th July 2026 is a public holiday or holiday for a tribunal. So then what is the last date for filing? Is it the preceding day or the succeeding day of the holiday? So as per General Process Act and at the same time GSTAT procedure rules also, if it is not a working day for the tribunal, the next day you can file the appeal. Okay, but now we are habituated to this online filings. So online filings, whether the tribunal is working or not working, I don't think that may not hinder filing our filing our appeal on the portal. So even if it is a holiday, in case if you are comfortable, we can file it. Okay, but as per rules, they told that we can file it on a next day.
Is there any condonation period available, sir, if you're not able to file within 3 months from the date of
Yes.
communication before the GSTAT?
Yes, Sriman. This is one of the important aspect actually in GST tribunal. So there is only upper condonation period of 3 months in addition to original 3 months. Okay, but in GSTAT there is no upper condonation period. That means there is no limit. Okay, a limit of period for which they can condone, even if it is 1000 days, 2000 days also. There are scenarios, there are cases where GSTAT has condoned the delay when there is a sufficient cause. But in tribunal, in GSTAT, the upper condonation period is only 3 months. If that 3 months is expired, 3 months plus 3 months is expired, then the tribunal is not having any power to condone the delay. Okay, tribunal and CGST Act being in its own, that means it has all the procedures set out on its own. So we cannot bring out Section 5 of Limitation Act, okay, to condone the delay. Tribunal cannot bring Section 5 of Limitation Act to condone the delay. The only mechanism available is you need to go and file a petition before the High Court, and you should get the specific directions from the High Court. Then only your case will be live. Otherwise, once the time limit is completed, you cannot file any appeal. So this is one of the important aspects which we need to be careful.
Okay, sir. Sir, as you said, taxpayer will have additional 3 months in addition to the original 3 months what we have. Now,
Yes.
since we all know the last date for filing and appeals for all the 17, 18, 18, 19 is 30th June 2026. For
Yes.
that day, from that day also, do we have additional 3 months of condonation period, sir?
Yes, Sriman. So this is one of the question which was asked by one of the participants in previous session. Okay.
Okay, sir.
So this, if you see the date notified, 30th June, it is as per Section 112 subsection 1. Okay, but Section 112 subsection 5 gives additional 3 months condonation period. So 30th June is a time limit prescribed by government as per Section 112 subsection 1. Okay, so subsection 112 subsection 5 is in place as on today also. So on reading 112.5, so we can clearly say that we have an additional 3 months time limit. Just because we have 3 months additional time limit, so don't delay your appeals. So the tribunal will condone the delay only when you show the sufficient cause. So what sufficient cause we need to show? The tribunal, they have opened the portal on 22nd September 2025. And they have given almost 9 months to 10 months time they have given for filing the appeal. So in case if you are filing the appeal within those 9 months, okay, so then it is very difficult for the tribunal also to condone the delay. So only on medical reasons or any extraordinary reasons only the tribunal may consider. Otherwise, it is very difficult. So I suggest to file all the appeals before 30th June 2026 only. Don't get into this condonation period.
Thank you, sir.
In fact, just one example, Simon, in
Yes,
one of
sir.
the case, although there was a medical reason and there was a delay of meager, I would say 2 weeks, but the bench for 2 weeks, every day they wanted a reason. Okay, Monday this was there. So why did you not do on Tuesday? What happened on Wednesday? Literally, they asked for 10 days. I had to give a proper reasoning. Okay, why it couldn't be done on Wednesday, then why not on Thursday? So sometimes, we don't know the bench may go a little, deeper into things. So there, and condonation, what happens at the moment we condone, already our case somewhere goes into back foot. So it's better to go into straight on merits before the condonation period.
Okay, sir. Ravi, sir, can you throw some light on the remand back provision, sir? Because in the GST, the first appellate authority does not have any power to remand back. Only the GST tribunal has the power to remand back. So what is this remand back provisions, and in what situations the GSTAT will opt for remand back in the case?
Your right question should be in what situations they will not remand back. And I'll explain you that.
Okay.
So remand back is, see, tribunal can either, accept the appeal or reject the appeal, or they may remand back the, appeal. Now, the point is, remanding back is something, a situation. Remanding back is a situation where the matter is being given back to the adjudicating authority, not to the first appellate authority, back to the adjudicating authority for some reasons. Now in GST, I have a fear that a lot of matters may actually get remanded back, because the moment there is, let us say, too much going into the facts and trying to understand the facts, all those things would be there. The tribunal at times, the bench will lose its patience. They may say, all these workings and calculations, you please do it, remand it back and come back again. So with remand back, what happens is, first of all, you lost your opportunity and we don't know when it will come back again. So don't be under the impression that remand back will come back immediately in 2 months. Need not be. Now, what is important, especially the way we are, approaching this tribunal. See, what happens is in GST, 70% to 80% matters are numerical based, reconciliation based. This number is not matching with that number. Now, I would have to prepare my appeal so precisely, so properly, with tables and all very clearly mentioned. Okay, this is the difference. This difference is there in this 4B2, and this is the what is disclosure in GSTR 9. So precise, so that I just explain to tribunal and immediately they should understand. Because if they remand back, the moment I go into Excel sheets and too much of number crunching, I know tribunal is going to remand back the matter. Now, so that is one skill we need to see, how we really put our facts clearly, concisely. Now, another thing is that, let us say the worst situation, that the matter eventually would get remanded back. Assume. In that case, as a person pleading, I should try to at least get the directions of the tribunal. So, tribunal can remand back with the directions that, okay, if this number is matching, then it should be allowed, let us say. So what happens is that if a remand back is there with the directions, then the original adjudicating authority then cannot apply their mind. All they need to do is 1 + 1 = 2. If it is 2, it is favorable. If it is not 2, it is not favorable. So if the matter is going into remand back, as a pleader, I would try to get the directions also. And as a first instant, I would try to avoid remanding also by putting the facts very clearly.
Okay, sir. Thank you. Sir, my next question is to Lakshman, sir. Sir, there will be scenarios where we file return submissions, hearing is conducted, but the authorized representative may feel that the members are not satisfied with our written submissions and our arguments. Is there any option or possibility available to authorized representative to make written additional submissions after the date of hearing?
Yes, Sriman. Good question. So practically how it happens is, so once you argue the case before the tribunal,
Yes.
okay, so they take the views of authorized representative and at the same time dear department representative, and they will come to a conclusion. So
Yes,
if they have arrived at a conclusion based on the submissions, whatever we have given, whatever arguments we have given, then they will dictate the order in the open court itself. If that is the case, then there is no opportunity for us to file any additional submissions. In such scenario, only thing, when they started dictating the order, only thing you can request the tribunal bench is to grant some time for additional submissions. So in case of the tribunal, it all depends on the members who are sitting on the bench. If the members, okay, feel that it is proper to give time for additional submissions, then they will grant time, specific time. For 2 weeks or 4 weeks, they give the authorized representative. It is based on a specific request. Only when you request, based on that you can take the time. But in case if the bench has come to a conclusion clearly, and they dictate the order, then it is not possible. And in other cases, instead of dictating the order, the tribunal may also reserve the order. Instead of dictating the order in the open court, they may reserve the order and they may give the order after some time. So in those cases also, you can request the bench to grant time for submitting the additional submissions.
Okay, sir. Sir, can you explain what is interlocutory application, sir? In what situations that authorized representative can file it?
Yes. So interlocutory applications are specific applications, Sriman. Okay, we discussed about this condonation of delay. When you are filing your appeal with condonation of delay, you need to give the reasons in that specific application. So for that purpose, you need to file one interlocutory application for condonation of delay. And at the same time, in case if you want to file any early hearing application, okay, for that you need to file one interlocutory application. So restoration of appeal. Okay, for all those things, okay, for change in cause title, for all these things, you need to file a interlocutory application. So that application would be heard by the bench. In case if they feel it proper, And in case if they feel it correct, then they will allow that interpolatory application. Like condonation of delay, they will hear it separately. Then early hearing application, they hear it separately and decide whether that early hearing application is allowed or rejected. Okay. For doing early hearing application, condonation of delay, restoration application, or for submitting any additional evidence, for all these things, you need to file interpolatory applications, and there is a specific fee for filing that applications as well.
And what about this rejoinder submission, sir? Can you
Yes,
explain it?
so yes, rejoinder comes into picture. So when as an appellant, okay, you file an appeal to the tribunal, and they will serve a copy of the appeal to the respondent as well. Okay, and respondent has a opportunity to file a reply to your appeal. Okay, so once the reply is filed and the respondent is bringing out some new facts which are not there on record. Okay, in those cases, the taxpayer is having an opportunity to file a rejoinder to the reply filed by the department representative, that is respondent. So you can give, in case if certain facts are wrongly mentioned, you can give your reply by filing a rejoinder. And that rejoinder would be filed within 1 month. Okay, and a copy to be served to the department representative. Okay, that is the respondent.
Okay, sir. Ravi sir, as we discuss about the GSTAT provisions and all, we all know there are different types of benches in the GST tribunal: single member bench, divisional bench, and principal bench. What are the matters heard by the single member bench or division bench or principal bench of GSTAT, sir?
So principal bench is based out of Delhi, and principal bench would be hearing anti-profiteering, place of supply, input service distributor, all these common matters involving national level, jurisdiction. The state benches, within that again, there is single member bench and divisional bench. Single member bench matters not involving any question of law and having pure question of fact would be heard by single member bench. And also cases where the value of the tax is less than 50 lakhs. So these are the cases will be taken up by the single member bench. But let us say if a matter involves some question of law, then even if the amount is 10 lakhs, it would still not be going to the single member bench. It would go to a divisional bench.
Okay.
Was I audible?
Yes, sir, you're audible.
So divisional bench has one judicial member and one technical member. Single member bench can have either judicial member or technical member. Hence, while drafting an appeal, it becomes very important for me to put up some legal questions so that I want even a judicial member to be there hearing my matter.
Okay. Lakshman sir, whenever we go to the tribunal, the first
so maybe
thing that
Sriman, maybe
yes,
another 3-4 minutes, let us wrap up our discussion so that we can give good 20-25 minutes for the participants Q&A.
Yes, sir. We have only 3 questions left.
Perfect.
So that we can wrap it up. Lakshman sir, what is the dress code as specified in the GSTAT rules for the authorized representatives when they are appearing in the GST tribunal?
Yes, Sriman. So GSTAT procedure rule says that the dressing should be as per their profession. So as a chartered accountant, they mention that we need to wear a coat along with tie. Okay. Coat, we need to wear black coat. And at the same time, in case if there is no specific dress code for that profession, so they told that okay, we can wear a white shirt along with black coat along with tie, or open-ended collar or closed-ended collar. So that is the dress code. For girls, it is white saree along with black coat or any other white dress with black coat. So that is the thing. During summer, okay, from April to almost August 31st. So there is a relaxation given for wearing the black coat. So that is the dress code given.
Sir, as we know, as we discuss, the employee or the relative of the taxpayer can be authorized representative. Will this dress code applicable to them as well?
Yes, in case if there is no specific dress code prescribed for their profession, okay, they need to adopt this white shirt along with coat and tie.
Okay, sir. Lakshman sir, based on your last 5 to 7 years of experience appearing before the GSTAT, could you explain what are the key courtroom ethics that authorized representative should follow in the GSTAT?
Yes. So few things what we need to do is, so whenever you are arguing before the tribunal, we should always okay, call that respective judges like your honor or my lords. Okay, that thing to be followed. And whenever you are arguing, you need to face the bench and you should not face the DR. You are only presenting your case to the judges and not to the department representative who is standing beside you. Okay, so that should not be the case. And at the same time, whenever you enter the court, you should keep your phone on silent mode, and you should not eat anything or drink anything in the court, open court. So that will disturb the judges. Okay, all these things they should not do. So whenever you are entering, so you should bow your head, and whenever you are leaving the court, then also you should bow your head. So that is a small etiquettes which we need to follow, and you should be silent. You should not make any noise, and you should not disturb the court. So these are the few things.
Yes. Ravi sir, you want to add anything regarding this?
Nothing. I think Lakshman has covered. Only one small thing is regarding drafting. Drafting the this appeals is an art. Many times we see that especially in this AI era. I think I don't know. Everybody knows the positives of AI for drafting, but I would want to highlight the other side. It is unfortunate that people are overusing AI in drafting. And I am seeing this as a worrisome situation because in AI, you can get 50 pages, 100 pages draft the way you want. But it is going to be a terrible situation if people use so much of AI for drafting. In my office, I have to restrict my people to use AI. That is a level which we have already come to. So it is a myth or a misconception that quoting too many High Court, Supreme Court judgments will make your draft as a very powerful draft, or giving a 100-page submission is something really fantastic draft. I think there is a saying that it takes 2 hours to draft 50 pages and 10 hours to draft 10 pages. Because there is a skill that requires where you need to communicate what you want to communicate without just putting the garbage and just being pointer to what you want to really say. In GST tribunals, our aim should be to win the matters on facts without even going into the act or rules, I must say, just on the basis of facts. That should be the first aim while drafting. But let us say if the matter involves a question of law, then we should try to draft in a way where by just giving the provisions of the act and the rules, we are able to get the matter communicated. Case laws and judgments and circulars are only an additional backup. They are not the primary submission. They are only, let us say, if I'm saying something, it is just adding weight to what I'm saying. That's all. But that cannot be the only thing. So drafting in GSTAT has to be very precise. Now, what we are doing quickly, because of this reconciliation, it becoming very difficult to explain. It is in paragraphs. So what we are doing is we are simply putting in some small tables in a tabulated form. So it becomes very easy to present to the bench, something like that. Let us say I want to give the whole history. Instead of putting in paragraphs, I'm putting in a simple table. So these are the things in drafting one needs to take care. Then of course, then there are so many other minuscule things that are there. That's all from my side.
Thank you, sir. Thank you so much. Shall we take up the questions, sir, in the chat box?
Yeah, we can go from the top, Sriman, so that
Yes, yes. The first question is by Hemant sir to Lakshman sir. Sir, in the slide number 18, which category to be selected for demand under section 129, that is before amendment?
Okay. So in case of detention cases, so there is no specific category. You need to select any other category, but there is one category which says that in case of seizure or confiscation of goods. So under 129, 130 pertains to confiscation. When it is confiscation, you can select that category. So, but otherwise, you need to select any other category. So in your case, there is a detention of goods. Okay. So any other category is relevant.
Okay, sir. Second question is, sir, does the name of the commissioner is required to be mentioned mandatorily if it is
No,
if he is a
no,
respondent?
no. In case of respondent, there is no. It is not a mandate to mention the name because it keeps on changing. Because there is a transfers of the commissioners, it keeps on changing. We need not mention it. It is sufficient to mention the respective jurisdiction, commissioner of so and so commissionerate. So that we should mention.
Okay. Is it required to digitally sign every page, sir? Every
Yes,
page
yes,
of the appeal.
So section rule 22 actually, rule 22 of GSTAT procedure rules, endorsement and verification. So it clearly mentions that at the bottom of the page, okay, both the authorized representative and the taxpayer has to sign on all the pages, including the relied upon documents.
Yes, sir.
So that is one of the procedure given. So we need to follow it.
Next question is in APL 5 form, we find there are 8 issues. 8
Yes.
issues in the drop-down list. However,
Yes,
on
yes.
the portal, we get only 4 tabs.
I think this is relating to levy classification valuation. Yes, that glitch is there actually.
Yes,
So
sir.
in
Yes,
portal, we
exactly.
are only getting 4 categories. So we need to select any of the categories from those 4. Those 8 categories which was mentioned in appeal form, the portal is not reflecting.
Okay, sir. Sorry, while calculating the court fees, should we also include interest and penalty in the disputed demand?
And no, interest is not required. It is only tax amount, fine, fee, and penalty. So those things
Okay.
are required to be included. Interest is not required.
Other than
So,
interest, every other amount is
but I will tell you one glitch. But I will tell you one glitch in portal. Okay, if you see the portal is automatically calculating the appeal filing fee. Once you fill the appeal, once you fill the disputed amount, okay, it is automatically calculating the appeal filing fee.
Yes,
But
sir.
the portal is taking interest also into account. If the interest is quantified in the order in appeal or order in original.
Okay, sir.
Okay, that glitch is there. Otherwise, as per rule, there is no requirement for including interest, but portal is considered.
Fine, sir. Next question is in case of Tran 1 matter, should we select others under the dispute of category?
Yes,
Is
others.
it
There is no
others?
specific category.
Okay. How to navigate the conditions for additional evidence under Rule 112?
I think this is already covered now.
Yes.
Additional evidence part I've already covered.
As an authorized representative, do we need to register separately for taxpayer and tax revenue department?
No, I don't think separate registration is not required. Okay, one registration is sufficient.
Punching is already covered. Digital signature is digital signature is acceptable? Yes, it is acceptable, right, sir? What is the time frame for getting the appeal registered in GST portal once an appeal is filed, if there is no deficiency?
So they are giving it within 7 days. So in whatever appeals we have filed, so within 7 days, when there are no defects, they are sending the appeal allotment number.
Okay, sir. Along with signature, is round seal is mandatory, sir, on the every page.
Yes.
One question here we have is, instead of round seal and manual signature, can we put digital signature on every page? Digital signature is fine on every page. Can it be replaced? Can digital signature replace round seal also?
Sorry, Sriman, I will stand corrected. So this signature is sufficient. Round seal they have not.
Round seal is not there. It's just that,
Not there.
we still keep as a, old tradition,
Yes.
but it is not
Okay.
mandatory round seal.
Okay, sir. Is it expected that the proceedings of GSTAT will be live on any website? As nowadays, proceedings of Supreme Court and High Court, we are able to see live. So,
I think nothing much has come update on that.
sir. Can we do self-certification for the orders issued in the local language and convert the same in English?
Can be done.
Self-certified can be done, sir.
Although it doesn't say that, there should be some certified translator like that. If you see this rule 23, it uses the word certified to be true certified copy by the authorized representative engaged on behalf of the parties in the case. It doesn't say any, registered translator or notarized, person or anything like that in the rule 23. So, correct, Lakshman?
Yes,
like-
yes, sir. Yes, sir. Looks like the same thing, sir. But the only thing is the other party also should agree to the translated copy, whatever you are submitting. We can convert and we can attest it, but the other party, DR, has to agree for it.
My only worry is that this whole thing is going to happen with AI.
Yes.
No.
And the person who is certifying, he should know that specific language and the English language, both the languages he should know.
Correct.
Lakshman sir, when you're answering the question around the e-way bill issue, he said,
Yes.
even though the person is unregistered, he can file an appeal in the state where the goods are confiscated or vehicle is confiscated. And the question is, can't we file the same appeal with the temporary registration number?
Yes, yes, sir. When TRN is available, we can file it. Because for
can file it.
TRN also we are able to get the registration. But the only problem is if it is manually. Yeah, if most of these 129 cases, we have done it manually in different states, and the office has also given manual orders. In those cases, it becomes difficult. So otherwise, if TRN is available and order is uploaded, then we can proceed to file.
Fine, sir. And other question, if the order is passed on January 1st, 2026, can I still file the appeal before 30th June 2026?
Yes, yes.
Yes, whatever orders passed up to 31st March 2026. Okay, further the due date is 30th June. In this case, it was passed prior to 31st March. So due date is 30th June.
And further period of 3 months of continuation is available.
Yes.
How to file GST appeal against only interest and penalty in the order, and is appeal rejected on delay ground? What is the deposit needs to be done to get the release of bank account freeze?
No, for bank account freeze, there is nothing like another deposit or anything to be done as such.
And if the appeal is rejected on the delay ground, I don't think so.
Yes. So
delay beyond condemnation, you are saying, right?
Yes, sir.
Yes.
First appellate authority has rejected the appeal because the appeal has been filed beyond the condemnation period.
So
the first appellate authority itself has rejected, you're saying.
Yes. So
correct. I think in the last session we discussed in detail on this. Yes, Lakshman.
Yes, sir. In that case, the appropriate forum is to approach the High Court, sir, because the tribunal is also not having any power to condone the delay. So it is better to approach the High Court and get the directions under Article 226 of Constitution. So
Correct.
that is
In
the
that-
appropriate route.
In that, one more thing in the last session, which I also mentioned, that you can look at challenging the very order rather than the OIA. You can look at challenging the OIO, very OIO also, because they may not merge as a principle. They may not merge. There are a lot of those judgments which I mentioned.
Okay. Sir, next question is, while filing the first appeal, we have made the pre-deposit to the extent that it covers the pre-deposit when we file appeal before the GST tribunal. In
Yes.
that case, do we have to make pre-deposit again while filing before GST tribunal, sir?
Not required.
Not required. How do we get the list of DR? Can we hand over copy of
What do
appeal
you
and
want to do
documents
with
to
the
DR?
list of DR?
No.
If you get that list, let us know also.
This question is particular to Ravi sir. When will Pune GSTAT get functional and where it would be?
So if the person knows the answer, they can let me know also. They can ping me. See, the thing is that in Pune, the infrastructure is still not ready. The last update I know is that, it was supposed to be in Akkud. It was originally supposed to be in Baner. Then they told Baner the infra is not ready. In Akkudi they will do. But as of now, there is no update so far as Pune is concerned. Most likely it should come in Akkudi, but we still don't have much update as of now. What's the position in Hyderabad, Lakshman?
Sir, Hyderabad, this registry court is functioning, sir. Okay, the judges are not sitting for hearing. Registry is functioning. That is in GST Bhavan third floor, and at the same time, there is one at BSNL building, sir, near Telugu Talli flyover. Okay, so in BSNL building, 9th and 10th floor, they are doing the works. That interior works are going on.
Mhm.
And as Sriman, one thing with respect to previous question, so they referred this rule 34 of GST procedure rules actually. So whether we can hand
Yes.
over the copy of appeal and documents to DR or not. So that rule says that as soon as we file the appeal online, a copy would be made available to the concerned respondent. So
Okay,
the
sir.
tribunal will do it, sir. We need to file it to the tribunal. Tribunal will hand over the copy to the DR, and we are not required to do anything. We need to communicate only to the GST tribunal. That's all.
Okay. In case of Tran 1 matter, should we select yes, other category under dispute of category? Sir, we are filing appeal using temporary registration, but it was not allowing us.
So
Using
any
temporary
specific reason we need to see why it is not allowing? Whether the registration itself is not happening or we are not able to proceed further into different apps or not. That we may have to check.
Okay. How to submit the copy of appeal to respondent? As Lakshman sir has said, tribunal will
The
allocate it
tribunal
to
will
the
take it, yes.
and which affidavit to be filed along with appeal APL 05?
Sir, this also we got this query initially. We approached the registry and registry told that affidavit is nothing but your APL 05 that we need to enclose. And there is no separate affidavit. So unlike if you see GSTAT, okay, we are filing affidavit for payment of pre-deposit. That we mention all the challan details in that affidavit and we get it notarized and submitted to the tribunal. But that condition is not there in GST tribunal. It is only
Even
APL
for
0.
condonation, we file affidavits in the GSTAT right now.
Yes.
Okay, sir. One last question.
So I think Sriman, Amit answered to that.
Yes,
query.
sir.
So he says the temporary registration number issue will be resolved provided we raise a ticket.
We can take up one last
One
question.
last question. Yes, sir. If first appeal filed by Mr. A as authorized representative and GSTAT appeal filed by Mr. B as another new authorized representative, can B bring new facts before GSTAT?
I already mentioned you cannot bring new facts. I mean, the facts, if it is changing the course of the case, it would not be accepted at all. Only, additional fact which is not changing the course of the case, subject to the rebuttal and the re-examination of this thing the courts may allow, but it's a little tricky situation, I must say.
Will this recording will be available on YouTube or some platform for future reference? I think we'll upload this in YouTube.
Yeah, it would be available on YouTube.
Yes. As per the circular recently issued, can you clarify the exact matters which will be taken by principal bench? I think Ravi sir has already discussed, no sir? What are the matters
Yes,
will be
yes.
taken by principal bench?
Yes. So this additional facts thing has to be, I think that is where our drafting skill and our skill would come into play on how to still communicate the fact what you want to communicate without totally changing the course of the case. It cannot totally take the case to a totally different, you cannot suddenly bring a new fact unless you should have to prove that, some reasons because of which you cannot bring out those facts in the initial stage. So that is something important. So I think we can close. If participants still have more questions, you can share it as an email to us. Our email IDs are available on our website. You can just send us an email, and I'm sure most of you are that way also in touch with someone from our office. So the idea of these two sessions, the last session and this session, was to bring out more practical nuance into this new world of GST Appellate Tribunal that we all are going to see. I really find that GST Appellate Tribunal is a decadal story that is going to happen. A lot of things that we actually thought are settled would unsettle, and a lot of things we thought unsettled would get settled. So I'm very clear the world of GST is definitely going to shake in next 2 to 3 years for sure. And this is first time that the number of benches, so many number of benches are going to hear. I am really flooded with the orders. People who really are passionate to learn GST, I'm sure it's a treat for them. But sometimes too much of what we do for our passion, so to an extent that it is no more a passion, can also, happen. So thank you all for patient listening. And we have tried our best to compile all the legal issues which we have covered in our earlier session and procedural issues that we have covered here. And in case we see some more major developments, we would continue to keep these type of sessions for all of you. So I would like to thank Chirayu, Sneha, and all the organizing team. And I would like to thank Sriman. In fact, Venkatesh was to take this session. Just yesterday, late night, we informed Sriman, and he was kind enough to, take the preparations from Venkatesh, handover, and early morning, 8 o'clock, he started his preparatory work. So thank you, Sriman, for keeping up in the last minute and very nicely moderating the discussion. And yes, I would like to thank you all, the participants, for patient listening.
Thank you very much for joining. Thank you all.
Thank you all.
Thank you.